will confess to everybody that I'm a bit self-conscious here. I've seen everyone talking today with these swank backgrounds. You have very nice homes and so forth, and I'm sort of in my dumpy little office. But and Lib Fleming has put us all to shame with a background of the San Francisco Bay for her presentation. But we'll soldier on. So we have. I'm happy to be moderating a panel that is going to make this light lifting for me because they're very experienced people. Frank Ellerbe is an attorney in South Carolina with an extensive practice in the utility area as well as in other areas of litigation and so forth. I've known Frank for a long time. We sometimes represent opposite sides. We sometimes represent the same side, but we're frequently before the Public Service Commission. It's always been a pleasure to encounter him. Sam Watson, I do not know as well, but he joins us from North Carolina. He is the general counsel of the North Carolina Utility Commission, has 25 plus years of experience in both the private sector and the public sector, and he's going to help us learn about North Carolina's rules on ex parte communications. And Lib Fleming brings us the invaluable experience of 12 years of having been a regulator with the South Carolina Public Service Commission, a past chairman of the Public Service Commission, who I had the pleasure to serve as chief administrator when I was there. And Lib is going to offer us the perspective of somebody who is on a commission and is governed by these ex parte rules. I think this is in addition to getting this valuable ethics credit, it's an important topic because the public utilities sector is probably scrutinized unlike any other law practice that I've been involved in. The rules may be the same, but the degree of public attention that is paid to an attorney, a commissioner, or a staff member in the course of their work is really unparalleled. As a result, sometimes we're working by the same rules as the judiciary, but it seems like we're observing them in different ways. And it's probably necessary in many ways because of the old adage and the rules of professional responsibility and the canons of judicial conduct that we not only need to avoid impropriety, but the appearance of impropriety. And the rules on ex parte communications lie at the heart of this. And so we are going to start with presentations from Frank Ellerbe and Sam Watson on the respective rules of South Carolina and North Carolina governing ex parte communications, which have some similarities and some significant differences, and then engage in a discussion that follows from them. We're going to start with Frank. Frank, or Mr. Ellerbe, you have the floor for the next 15 minutes, uninterrupted.
Thank you, Charlie. If we could see the next slide, please. There we go. Thank you. So I'm going to talk about the ex parte communication rules that apply in South Carolina were adopted by the General Assembly in Act 175, adopted in 2004. Before I talk about what happened in 2004, I'm going to describe for y'all what it was like practicing at the commission before that, because my observation today, a lot of you are much younger than I am and don't have that experience. I started doing utility work in the mid 80s, and the focus then was on telecommunications, because the telecommunications marketplace was transitioning from a traditional monopoly rate-based regulated system into a more competitive system like the one we have today. It is different from, but similar in a lot of ways to what's going on today with the transition in the electric industry from a regulated to somewhat less regulated, more competition, questions about subsidies and cost shifts and things like that. All of that is very familiar. All of those concepts are very familiar to people who practiced in the 80s and 90s in the telecom area. So at that time, I was representing the non-incumbents, telecom folks. And I can tell you that people on my side of the issues back then were very frustrated with communications to the commission and with the commission. And there was a perception that there were paths of communication that were available to folks who had relationships that weren't available to the newcomers, that the incumbents had an advantage. Just to give you some examples of things, there were staff. You could talk to staff about matters pending before the commission, the same staff that would be advising the commission at a later time. Now that changed, a recognition that that was problematic changed over the years, but still it wasn't clear. It wasn't transparent when you tell staff something, whether it was passed on. So that was a concern. The other thing that were concerns were commissioners having private meetings with utilities before matters got filed, but maybe very close to something being filed. There could be a visit, and I've never participated. It's my understanding that sometimes the visits were with less than a quorum of the commission, so that there was no violation of the open meetings laws and requirements of the Freedom of Information Act. But those things caused a lot of concern. And there was an incident around 2002 where an email was sent to somebody. It was copied to a person that wasn't intended to receive a copy by autocomplete, and somebody being inattentive. The email went to a lawyer at the Consumer Advocate's office. That lawyer thought it was an improper communication, or at least if it wasn't an improper communication, perhaps it should have been an improper communication. That lawyer turned it in to folks at the South Carolina Senate. I think there were hearings. The commission elections were put off. Eventually, Act 175 of 2004 was adopted and in large part to address some of the issues that I've been describing to you. The Office of Regulatory Staff was created. The commission's role was changed from advocate, investigator, and adjudicator. The commission became the judicial or quasi-judicial body. ORS took over the role of investigating and advocating. Act 175 applied the Code of Judicial Conduct to the commission and the staff. Act 175 adopted very specific, pretty tough requirements for ex parte communications. But I can tell you that the things that I described to you, the general concerns that were in place prior to adoption of Act 175 are the explanation for some of the things that are in the law now that seem frustrating to folks who don't know about the origin of it. If we could have the next slide, please. So here's the basic rule on ex parte communications. It's found in 58.3.260, a broad prohibition on any issue that is an issue in any proceeding or can reasonably be expected to become an issue. Now, the reasonably expected to become an issue is in there. It's my understanding that was in there because of the practice on some occasions of utilities or parties having conversations in advance of a filing that would have put an issue into, created a proceeding in when an issue was, during which an issue would be presented. If you had the discussion before that, the belief was at that time that that was not an improper communication. So the language of 58.3.260 was chosen specifically to address that. That was seen to be a concern. There are some exceptions. You can have communications with staff, procedural scheduling. I won't go into the details of that. I would tell you that that's something that people practicing at the commission need to be very, very careful about. The best way to do that is by email with copies to all parties, especially ORS, and with status conference with staff folks over there to get everybody on the phone and talk is the best way to have those communications. There is an exception for attendance at seminars, but that one is tricky because the seminar, one of the things that used to happen prior to 2004 was perhaps an industry group would invite a commissioner to speak and to attend a seminar at it's my understanding, I never went to those. My understanding went to nice places, and the commissioners would attend the seminar and have an opportunity to spend some time with folks. So the language is that the seminar cannot be affiliated with a utility. So commissioners go to CRUC, commissioners go to NARUC. It would seem to me that an E4 type seminar where you have a broad range of utility and non-utility other stakeholders is something that would be consistent with the statute, but I understand that some commissioners have been advised otherwise. The most significant exception to the broad prohibition on communications about matters is the allowable ex parte briefing. And if I could have the next slide, please. So this is the rules on allowable ex parte briefing. It's found in subsection C6 of the 58.3.260. Notice of the briefing has to be posted in advance. Any documents used or referred to must be made available. A record of the briefing must be made and certified by ORS. And that includes a requirement that ORS have everybody who participated in the briefing, everybody who is present, sign a statement agreeing to basically to what happened during the briefing. The briefing has to be scheduled in a way in advance of the hearing, for example, such that any other interested parties would have an opportunity to have their own briefing to respond. So scheduling is important. There are requirements about that to give people an opportunity to respond. The last bullet on this slide is really important, and another thing that I can give you a little bit of background on. I was involved in some of the discussions and negotiations about these things, and I do remember. I hope I'm remembering accurately what went on about all this. I believe I am. The expectation at the time that this statute, this provision was being negotiated and then adopted by the General Assembly was that these briefings would be taking place, at least in part, in private, with fewer commissioners than would constitute a quorum. There is a federal, at the time, and maybe still it's the case, the Federal Communications Commission had a procedure that allowed interested parties to go and meet with commissioners on an ex parte basis, and then within a certain amount of time, a notice and a description of the conversation and the discussion would be posted or made publicly available. And that was to some degree, the model here. The expectation was that the ex parte briefings would be private, and that's why the ORS has to attend to police them. That's where that requirement comes from. That's where the requirement that ORS have everyone who attend a briefing sign a statement saying, yes, I was there and this is what took place. And that's why all the documents have to be made available. What has actually happened since 2004 is the briefings have been all done publicly. And if I can have the next slide, please. So this is the way allowable briefings have been conducted in practice, and it's a huge improvement over the private briefings that were expected at the time the rules were adopted. The party desiring to have a briefing contacts the commission. The briefing is scheduled. Notice is posted on the commission's website. The briefings have been, my belief is that all of the briefings have been provided in the commission's hearing room in an open session. They're now live streamed. There is a record of both transcript and exhibits that is made and is readily available on the commission's website. It's an extremely transparent process. And you can go back for years. I believe you can go, they're archived, and all of them are available going back years. And you can see what people have had to say about issues over the years as they've appeared before the commission. In my experience, they've been extremely helpful for the commission. They've been an opportunity for commission to hear from interested parties and ask questions. It's an opportunity that people, other stakeholders, other folks that have an interest in the issue can watch, listen, read the transcript, schedule their own briefing to respond and offer their views. All of this is a great way to get the issues fleshed out for the commission to some degree before a contested case hearing. Or even if, this may apply to an issue that's coming up in 6 months or a year or something. There have been updates to the commission on issues that are pending but are well off in the future. But I think my observation is that the commission has appreciated them and has enjoyed them and likes to have an opportunity to ask questions. They're for the benefit of the commission, but they're great for the parties also. I have recommended them to lots of clients. I think we're going to get into, I won't talk about it now, the pandemic the pandemic rules require the briefings to be conducted virtually now, and that has presented problems. The Office of Regulatory Staff has taken the position that virtual proceedings can't be conducted consistent with the rules under subsection C6. It's a real shame. We've got a lot of new commissioners, and briefings would be extremely valuable to them on a lot of issues. And I think all of us that are interested in these issues need to find a way to address that so that we can take advantage of this great tool. But that's my overview. I'll turn it back to you, Charlie. Thank you.
Thank you, Frank. We've asked everybody to hold their applause until the end in the interest of time. And I'm going to turn it directly over to Sam now.
So I have a couple of just introductory slides. I'm just a staff person at the commission, so I have to recognize the commissioners. And the next slide has all their pictures, so come up and see us sometime. And I wanted to just take a minute before we started to plug another program that we have up in North Carolina. I know both states' bars have certified legal specialists, and we actually created a specialization in utilities law a few years ago. And so I would encourage any of you who are North Carolina licensed lawyers, check that out. maybe down there in South Carolina, talk to your bar and see if there's any interest in doing specialties for utilities. I think we might be a little bit farther down the road. I know we've got a lot more different specialties than South Carolina does. So maybe utility law is one of those that's way down on the priority list, and family and estates and appellate and all those other things, people are clamoring for those first. But it's an interesting tidbit. I've seen a couple of folks on here today that have taken and passed the specialist exam. And so, certainly congratulations to those folks. They asked me to take the exam, and I was worried, what happened if I failed it? But fortunately, that was not a problem. Let's go ahead and move on then. And I guess I gave the moderator a chance to use this joke. We're the last panel between you and happy hour. But since it's virtual, you have my permission to go ahead and open your beers anytime you want. So since this is, one of the things that I found with the pandemic, one of the ways that it's affected me the most is resources. There were a lot of resources that I was used to having hard copies or just, accessible. And one of them is Black's Law Dictionary. So I started here with the definition of ex parte, just sort of get us started. And, I would have gone down the hall and looked it up in Black's Law Dictionary, or perhaps pulled my old law school copy off the shelf. But I found out that LexisNexis doesn't have Black's Law Dictionary online. So I had to resort to Valentine's Law Dictionary. And then for any of you out there that aren't lawyers, just in plain English, it means only one side. I think we all sort of figured that out, but ought to start with the basics here and a definition. So if you'll move on. So the other place I wanted to sort of start is, since we're all lawyers, actually the rules of professional conduct apply to the lawyers that practice before the commission. And right there in the rules of professional conduct, it says, don't communicate ex parte with the judge on matters pending before that judge or official. So, not only do the commissions have specific rules, but, really, we are a tribunal, we're a decision maker. And so you as a lawyer have an ethical responsibility under the rules of professional conduct. And I imagine that South Carolina has a very similar provision that tells you, don't even engage in this sort of stuff. And then I'll add, for purposes of this rule, because I think it applies just as well to our specific case, that ex parte communication is a communication on behalf of a party to a matter that occurs in the absence of the opposing party, and a matter is pending before a tribunal when that tribunal has been selected, or when it's reasonably foreseeable that that tribunal will be so selected. So let's move on to the next one. My judges, my commissioners are also, I heard the South Carolina is the same. Ours are also bound by the Code of Judicial Conduct. The South Carolina law, of course, was much more recent than ours, and I think that's why it's much more prescriptive. We split out our consumer advocate from the commission way back in the late 70s. So we've been operating with the kind of separation that has only been the last 20 years was done in South Carolina. But here's my judges, and I title this sort of from both sides of the bench, because these rules apply in part to the practitioners, but also in part to the commission side. So we should be just as keen on the commission side, the judge's side, in terms of ex parte communication. So the responsibility is not entirely on the practitioners. And here you'll see that in our Code of Judicial Conduct, it says a judge should not initiate or knowingly consider ex parte communications concerning a pending proceeding. So let's move on to the next one. Now I'm going to, so you can let's go ahead and step through this. This is our provision on ex parte. So let's sort of take this apart. If you'll move one more. And it starts out here in all matters pending, and all matters and proceedings pending on the commission's formal docket. So when you talk about what do our ex parte communications, what's our prohibition strictly apply to? First of all, it's all matters and proceedings that are pending on the formal docket. Now, if you'll skip ahead, with adversary parties of record. One more, all communications and contact of any nature whatsoever between any party and the commission. One more here, which pertain to the merits of such matter or proceeding. So we've set out sort of a checklist of things that say, well, is it an ex parte communication that's prohibited under 62270? You know, first of all, it's got to be related to a matter or proceeding that's pending on the formal docket. It's got to be a docket where we have adversary parties of record. It's got to be, well, any communication, really, any communication or contact. So that's a pretty easy one to check off. It doesn't matter how, whether verbal or written, formal or informal. But then it also has to pertain to the merits of such matter or proceeding. So one more there, it says, all parties shall have an opportunity to be fully informed. So that's really the rationale, the reason behind this is just fairness, due process. You know, you want to make sure that all parties are fully informed as the nature of the communications and they have an opportunity to be present and be heard. Let's see skip ahead. So just want to say that, you know, sometimes, I mean, I hear interesting anecdotes in other places, you know, like, for example, you know, I recall hearing that on the Supreme Court, the justices can't talk to each other, so they send all their law clerks together. You know, you can't say, well, I'm not talking to the commission, I'm talking to the commission staff, I'm talking to one of the engineers or accountants or lawyers on the commission staff. You know, here, really, if any party of record confers with otherwise contacts any staff personnel employed by the commission regarding the merits of a pending proceeding. In the judicial conduct, it says the judge shall require staff and court officials to observe the same standards of fidelity and diligence that apply to the judge. So we don't cut hairs that fine. You know, I mean, it's ex parte communication, whether you're talking to advisory staff or whether you're talking to the commissioners themselves. Next slide. So what do we do if, and you know, I mean, there are occasions where we've had ex parte. I mean, I think we actually have a pretty good bar, and we rarely get into instances of ex parte communication. So, you know, I want to thank those folks that practice before the commission that keep us out of these issues. But we do occasionally, you know, sometimes we'll get folks that don't know better. We'll send emails directly to commissioners, and they should have gone through the clerk's office. So we will send them over to the clerk's office to be put in the record. If we really have ex parte communications, then we're supposed to report those to the Attorney General. So any commissioner who knowingly receives, any hearing examiner who knowingly receives, so those are supposed to be reported to the Attorney General. Next slide. And then the rest of that section says, well, what if you don't? You know, I mean, this is why we take this seriously. There's, you know, it's sort of like in general in law, you can do a lot of things and mess up badly, but if you commingle funds, your history. These are one of the things that will really cause you to be dismissed, and ex parte communication. Any commissioner is liable to impeachment. Any staff member, examiner is subject to dismissal for cause. So we take this ex parte communications very seriously at the commission. Next slide. And then even though the chapter 6270 applies only to matters on the formal docket, really the Code of Judicial Conduct, as was mentioned earlier, applies even to issues that may come before the judge. So here under the Code of Judicial Conduct, the idea is that the judge is supposed to avoid an appearance of impropriety. So even if you have issues that are likely to come before the commission, we shouldn't be engaged in discussions on the merits of those proceedings, because we don't want somebody to accuse us of bias. I mean, by the time that we can unfairly decide the case because we've already engaged in one-sided communications. So most of the time, that's not an issue. If I'm talking to somebody, I know when to say, we probably ought to just not talk about that kind of stuff. And again, most of the folks that appear before us, they already know what is off limits or not and shouldn't talk about it. So that's a sort of before filing. I'll just mention on the next one that there's not really an ex parte decision question, but we don't talk about our decisions after they're made either. The commission must fully set forth its decision in writing, and that's so that it can get appealed and properly considered by the Court of Appeals or the Supreme Court. Anything we have to say, we should say in writing. And if a party's got a question about, well, what does this mean? They should file a motion for clarification. I can't tell you what went on during that decision making. I can't tell you why we reached a decision other than what is on paper in the commission's order itself. I will get media journalists all the time that will call me up and ask me to explain the decision. And I will politely point them to the decision, and I will read them sections out of it and tell them they can quote from the order all day long. But I can't explain the decision. They're welcome to draw their own conclusions and say anything they want about it. But I cannot further discuss it. Let's see, one more perhaps. So then the other question comes up, well, what is permissible ex parte communication? And, I guess the question is whether it's even ex parte communication if it's permissible. But that same 6270 says that we may meet with folks, receive communications ex parte in matters not under this section. So all the stuff they said you can't do, we can meet for the purpose. It may secure information and receive communications of being the purpose of the section to protect adversary interests where they exist, but not to unduly restrict the administrative and legislative function of the commission. So, we can talk to folks about matters that aren't pending before us. Certainly, I mean, we're interested in stuff that takes place at FERC. We engage as a body with the other states that are involved in PJM. We occasionally hold educational conferences in terms of, you may be familiar that last year we held a series of conferences where we invited experts in to talk about battery storage. We chose to do those in an open proceeding. I mean, open as in publicly, folks would come down and see it. We didn't allow them to participate, but we wanted to make sure that they knew what we knew. So when the experts came in front of us and gave us their opinions on battery storage and the future of battery storage, we opened that up for folks to be able to view them. And I will say that one other perhaps benefit of the pandemic is we were not technologically able to stream our proceedings since we have been have upgraded, and now we've been doing our stuff virtually. We have been using WebEx, and we've been streaming on YouTube, so folks have been able to see what's going on, to attend our hearings virtually. And we've actually installed couple of cameras in our hearing room. So we're looking forward to being able to continue to stream some of our stuff in the future, even when we actually get back into the hearing room. I think that that does it for me, and that's pretty much wraps up my time frame. So thank you, and I guess the last thing I will say is, feel free to contact me, our staff, anytime. I mean, the ex parte rules are there to prevent us from engaging in, as a saw, protect adversary interests. But we are definitely a resource, and so don't hesitate to call on us. And I will let you know if you ever get close to the line, so that we don't cross the line and we don't engage in any ex parte communications. But we are certainly, we're happy to talk to folks anytime.
Thank you, Sam. I'd like to turn to Lib Fleming to just give us some comments on her perspective of these presentations and what she's heard. We hadn't expected a formal presentation from Lib, but she can give us a unique perspective, and then we'll go into a discussion. We already have some questions in the chat room, and I have a few questions of my own. But first, let's hear from Lib about this.
Well, that was unexpected, Charlie. First of all, I'd like to thank Bonnie and the E4 group for inviting me to participate. And I'm very happy to be on a panel, or I was till just a few minutes ago, with Charlie to talk about these issues. Charlie led us through Act 174 very ably, and he became a good friend in the process. And so I have great respect for him, what he does. And Charlie, least we forget, it was 14 years. I would maybe like to forget the last two, but they were kind of bookends. I started with Act 174. I applied to be a candidate in 2002 for what I thought would be a 6-week process, and it turned out to be a 2-year process because of putting together Act 174. And now I ended on a note that was full of disruptions as well. So a lot of new things are coming down the pike as a result of that, not all bad. We came under there were 4 of us who came on the commission with Act 174, and we were so intent because there was so much tension of what had gone on before. We were so intent to get the job right. And I think we did a very good job through the years. But living with ex parte can be very difficult at times too, because it puts you in such a silo that people outside just don't realize how isolated the South Carolina Commission is about what is going on. And that's why I think some of these things that are a part of Act 174 are so important, like having the briefings and the workshops. And I'm sorry to hear that they are on hold for the present, especially with new commissioners, because that is an invaluable way for us to learn, and especially with electricity being such a dynamic industry through this century, it's just really important for commissioners to hear from all parties about what's going on in this world. So, and the other thing, when we came on the commission, PERC, our review committee, said to us, we want you to be the best educated commission we have. So they encouraged us to go to every educational opportunity we had, every seminar, be participants in the national organizations, which I felt was one of the most important things that they did, because the opportunities were endless and they were so helpful, especially living under the ex parte rules that we were under. I do think there is room for consideration of maybe some modifying some of it. I think some of that is already going on. I did feel like with the VC summer, if we had been able to possibly make site visits, we weren't allowed to visit even any sites associated with utilities that we regulated, that we might have had more opportunity other than just what we were hearing in the hearing room to get a feel for what was happening on that front as well. But all in all, I loved being a commissioner. You hear it over and over that it's the best job you can ever have. And I tell you, I have become a true believer in that. And it's very important work that I enjoyed with the people I was working with. Anything I should add?
No, I'm slow to unmute. That was great, Lib. That was a very good perspective on things. And we kind of went through the commission, those first years of the commission together, and learned the rules of the road, so to speak, because they were undefined. And Frank brings up a very good point, for instance, about the ex parte briefings, in that they were, if you read them on paper, they're designed like ex parte briefings to federal communications commissioners. And I've had an ex parte communication briefing with the FCC commissioner. I can tell you it is nothing like a briefing at the PSC. But in some ways, I think that's good from a transparency standpoint, in that they're broadcast, everybody can see what's going on, everybody can get the materials. I like that part of it. I don't want to get in the weeds of our ex parte laws, because I think it's beyond the interest of most of the people in attendance here. But I am dismayed. I had not known that commissioners couldn't have allowable ex parte briefings under the pandemic rules. Frank, maybe you can enlighten me about that offline. I'm hard pressed to understand why you can have a rate case online but not an allowable ex parte briefing. But we'll leave that to another day. And we have questions in the queue. I'm aware of them. We can get to, but one thing I want to talk about pandemic related, which is interesting to me, is Lib mentioned the value of NARUC and CRUC and these conferences that commissioners attend, and I agree. But one of the things that was always problematic about them is, for one thing, they're always in far-flung places, so everybody's got to travel. There's expense related to that. And then there are people that'll criticize you for traveling. And then there's the issue of, well, what happens in the hallway and all that. Is one positive aspect of the pandemic to move some of these things online and make them more accessible to the public at large? I'm just interested in everybody's thoughts on that.
Well, I think that maybe not the pandemic, but one of the best things that that Commissioner Fleming and her colleagues did was move and I mentioned this before, but move the allowable briefings into the hearing room and make them open to the public. And all or almost all of the commissioners were there. So there's a quorum. They weren't taking any action, but there was so much more transparency. And I think Commissioner Fleming is exactly right that when she and the other folks that came on the commission at the time that she came on, they were following that incident that I described and that she described that took 2 years to resolve. There was a legislative impasse about whether there were going to be elections or whether we were going to have reform and then elections. And Commissioner Fleming and the others were held hostage to the reform effort. And eventually that's what we have now. And I think they took the really smart approach of making sure that any of the briefings took place in the open hearing room. They're now live streamed and transcripts are available. And that as I tried to tell a legislative committee that had a hearing after the VC Summer project, that our commission was probably the most transparent state agency I could think of, because that they've conducted themselves that way. I think in South Carolina there aren't any private communications now with staff or with commissioners about things that shouldn't be communicated in private. So I think the commission has done a great job of that. The putting everything online now, it was already online, Charlie, even before the pandemic. So I think that that the commission has done a great job, and South Carolina has done a great job of making its activities transparent. And I think it was necessary to try to restore confidence in the commission after what happened in the early 2000s. Commissioner Fleming mentioned the more recent controversy arising after the failure of the Summer project, and that ratchets up the scrutiny on the commission. That's going to make it harder to relax the requirements. My expectation is that if you want to go in and ask for modifications to make it easier to have communications with the commission, the intense level of scrutiny that was generated by the VC Summer abandonment is going to make that more difficult. But there are very good arguments for changing the rules some. I think we'll just have to be really careful in how we present that.
I would like, if y'all don't mind, because I want to make sure we get to this question, I'd like to call on Thad Culley, who wanted to has a question that involves will require him to explain some California Public Utility Commission rules as well. So if we could give Thad the mic for a minute, that would be great.
Oh, that's very generous of you. And I don't want to be that person that has the 5-minute question. So I'll try to be as brief as possible. And honestly, Steve Levitas has articulated this pretty crisply. In California, of course, you can have, there's no restriction on ex parte communications in a quasi-legislative docket. But when it's a rate setting, you can still meet with commission staff, as long as within 3 days you file a notice of that communication describing who was there and what was generally discussed. If you were to meet with a commissioner, they would have to grant equal time to all of the parties, which would happen occasionally. But as you can imagine, most commissioners were loath to give up their schedule in such a way. So I guess the point I wanted to make and ask, kind of open to the panel for their reactions, would be, is a permissive structure like we see in California something that would be of interest? And this certainly, it lays out the rules and expectations very crisply in the regulations. So I think parties know what their expectations are and how to comply, how to stay out of trouble. But that doesn't mean there was never any trouble. There were still some examples of the commission president having an inappropriate conversation in, I think, another country. They were in Poland with an executive of a utility, and that became a really big story. So, even good rules don't eliminate all bad behavior. But wanted to see, to Steve's point, doesn't this really throw the door open and help improve public policy by, as we're encountering a lot of novel and complex technical issues, giving staff who are working on these issues really in the trenches a chance to talk with the participants to understand not only their points of view, but what they're presenting, and eliminate any uncertainty. I'll stop there. That was a 5-minute question. My apologies.
Let me ask you a clarifying question before we go forward. Can you describe the relationship of staff and commission in California and tell us whether it is analogous to South Carolina, in which you have independent consumer advocate, an independent office of regulatory staff, and then a commission that's functioning in a purely adjudicatory manner?
Yeah, and when I was talking about staff in that sense, they have a separate division of ratepayer advocates. They've switched names several times, but so it's more like ORA. ORS, I'm sorry, and the staff dedicated. So each commission had their own staff of several that were dedicated to water, electricity, et cetera. And so I know we don't have the personnel, it's a very large state, to do that for every commissioner, particularly with 7. But yeah, that's what I mean when I say staff. These are professional staff dedicated to each commissioner on a particular topic.
I'll turn it back over to the panel then for their reaction to this. Is this framework, I guess what Thad's asking us, would there be advantages to that kind of contact, or is it just something that, South Carolina and North Carolina really can't handle very well?
Well, I'll venture a comment, and that is that you are more than welcome to talk to our public staff, our ratepayer advocates, all day long as they'll listen to you. The prohibitions that I've discussed have to do with the commissioners themselves and the advisory staff. Although I appreciate the distinction that Steve raises between quasi-judicial and quasi-legislative proceedings down at the commission, as a practical matter, our rate cases are hotly contested. And although, for some purposes, calling them legislative is helpful, here for purposes of ex parte and deciding matters on the record, I think that the ex parte prohibitions still appropriately provide due process protections for all of the other parties. Again, our rate case orders, these quasi-legislative functions, are appealed directly to our state Supreme Court, and they have to be based on competent evidence that's in the record. And so, for us to engage in ex parte communications that other parties are not privy to, that they don't have the ability to cross-examine those witnesses on, just seems fraught with just raising the opportunity for endless litigation over what we based our decisions on.
And for purposes of this question, let's stick to the issue of communications during contested cases such as rate cases. I think Steve is raising a slightly different issue, and I think it might be useful to talk about those distinctly. So I guess I would ask Lib, Frank, do you have anything to add? Do you think it's useful, as Thad describes, to be able to allow folks to talk to staff in the course of contested cases and, produce a summary or something later on so everybody's on notice? Or is that kind of going back to where we were and not so good?
Well, I'll speak really quickly. I don't want to preempt Commissioner Fleming, but our allowable our prohibitions on communications do not make a distinction between, for example, contested case hearings and rulemaking proceedings. It would be possible it would be possible to have an allowable ex parte briefing with staff. And it wouldn't be very much different from what Thad described. You'd have to give notice. You'd set something up with staff. You'd go out. You'd meet with the staff. You would have to be accompanied by somebody from the Office of Regulatory Staff, and there'd have to be a record of the meeting. Any documents provided to the staff member would have to be made available, staff member or members. You can have a briefing like that with one commissioner, with a couple of staff people. As long as those things are permitted under the South Carolina rule. You just got to jump through the hoops of giving everybody notice of what was discussed, and give other people an opportunity to go, as Thad described, to go and make a alternative briefing. In my experience, in my view, what our commission has done by having the briefings, these allowable briefings done in public, done with the whole commission and relevant staff present in the hearing room, Steve, I know I've seen Steve make a presentation, a very effective briefing to the commission on issues that matter to his client. And I think that's been, that just adds so much transparency in this time where there's so much suspicion of bodies that are making these decisions that are hard for the general public to understand. And the more we do things behind the scenes and out of sight, the less likely it is to persuade people that they're being done for the right reasons. So I think transparency is not just a way to get a good decision. Transparency is important in its own right. It's a goal, not just a means to get to the right end. It's a goal also. So I applaud the way that the path that Commissioner Fleming and the former clerk, Mr. Terreni, charted for us in the 2000s. And I think it's effective, and I think it's a good model.
Lib?
Yes, I have several thoughts about this. I'm concerned, as I said, with how dynamic this sector is, the electric utility sector, that the commissioners are able to get the education and knowledge they need to make informed decisions. You have smart grid. Before, we never were involved with transmission, never really had any interaction with FERC. And we're dealing with technology that is totally new and very complex and complicated. So there's got to be a way to bring that information to the commission. I'm fine with it being ex parte. I'm not even sure if, but these things, we need to be having workshops. They are coming along. Well, before I left the commission, they were fewer and fewer in number. And I think that's an excellent way to be able to come to commissioners and have your voice heard. I do think, when I said I think it needed to be massaged, like a seminar like this would be great for commissioners to be able to attend. I'm not sure under the ex parte rules right now that it would be considered something that a commissioner could do, because these people come before our commission. And right now you're prohibited from going to a utility sponsored seminar that is under the authority of the commission. And those are the places where you, commissioner, can find out the needed information to make informed decisions. And I just think it's so important that those opportunities are there and are made available. And having it South Carolina or North Carolina oriented is much more pertinent to what the commission is deciding on, in addition to what they learn on the national level, if that makes sense.
You know, Lib, I have to agree with some of what you're saying. I mean, I think you were saying bring it in an ex parte, allowable ex parte briefing if you need to, but they need the information. I see the commission presently, for instance, is struggling with the scheduling of an educational seminar on energy issues. I mean, it's become a docketed matter. I don't know that would have happened a few years ago. I think the commission is being sensitive to the concerns that Frank raises, and they're entirely legitimate concerns. And all I would say is I'm all for the participation, but I would come back to the issue of access. If one of the problems with some of these seminars is they're not accessible to everybody, to the full range of people that participate. And that's always kind of a thing. But again, this is maybe where utility law is different than, say, tort law, where nobody thinks twice about a judge going to the Defense Trial Lawyers Association weekend at Hilton Head and then going to the Trial Lawyers Association, or Access to Justice, they call themselves, the next weekend at Hilton Head. I mean, it's just kind of what happens. But we can't do that. And I think we can't do it with good reasons. But then it becomes an issue of, we're going to have these seminars and things. Who gets to go? Is there a barrier of entry? Do they cost $1,000? Do they cost $200 for a commissioner, or and $500 for the public? It's a complicated issue, but one that perhaps is made a little bit easier by the online environment. And I want to give Steve Levitas and then Hamilton Davis an opportunity to weigh in and ask their questions, because I think Steve was going in a slightly different direction. We've been talking about access in contested cases, and Steve's saying, well, what about the regulatory, quasi-legislative, not as opposed to quasi-judicial functions of commissions?
Yeah, thanks, Charlie. And I'm glad you make the distinction, because I really was not talking about a rate case. I know Thad described a procedure that might be applicable in a rate case, but let me give you a couple of real world examples. In North Carolina, as we've heard today, we passed in 2017 a comprehensive energy bill called House Bill 589. Two of the sections of that bill dealt with new programs. One was the competitive solicitation, or CPRE program. The other was the large C&I program, Green Source Advantage program. As is always the case, about what they should put into that bill and what those programs should look like. And that's, of course, entirely permissible. It's not considered an inappropriate ex parte communication. And then we get over to the commission when it's now its turn to flesh out the details of the program. And because that is done in a formal docket, it is absolutely quite quasi-legislative policy making. It has nothing to do with a judge-like proceeding. But we can't have a conversation, nobody can have a conversation with anybody about the policy details of designing the program. And it just seems not only asymmetrical, but really bad from a public policy standpoint, because there's just not the free exchange of ideas that can occur in a back and forth conversation. So that's where I'm coming from. I'd be interested in people's reactions.
Well, since you mentioned North Carolina, I will say that even if it's not technically prohibited, we have chosen to treat ourselves differently from the legislature, where lobbyists are common and fraught with their own issues. I guess the thing is, while some parties would like to be able to come in front of us, do they really want us talking to the other parties? So the better practice for us has been to keep everything on the record. Tell us what you want to tell us in an open forum that everybody else is aware of what we're communicating about. And so even in a rulemaking docket, we'd still prefer to run all those things through written comments and filed with the clerk's office.
Anyone else?
Could I ask a question of Steve?
Please.
Are you saying that having a workshop will not satisfy what you're asking for? Would you be satisfied with a workshop with all commissioners present? And
I think the problem, Lib, is that in complicated policy making, there's just a lot of benefit from being able to have a back and forth, unrestrained, regular conversation about issues. People can bounce ideas off of everybody who's involved. And the downside is that something untoward is going to happen, or something inappropriate is going to happen. And we do have, as Sam alluded to it, we do have, of course, lobbyist registration laws. In North Carolina, those apply to communications with administrative agencies. and reporting that's required for that. But my concern is just getting a good public policy outcome for the people of the state that I think comes from a free exchange of ideas. And I would say that, and two things I'll put in my question. One, at least speaking for North Carolina, I'm not 100% sure South Carolina, but we have dozens of other regulatory commissions in our state that perform both quasi-judicial and quasi-legislative functions where ex parte communications are not prohibited with respect to the policy making. And similarly, Thad mentioned California. I'd be interested to look around the country, but I know a number of other state regulatory PUCs, utility regulatory commissions, make this distinction and do not prohibit ex parte communications with respect to policy making. I just think it's an issue that deserves further consideration.
When I was speaking, really thinking more policy making than an actual rate case that was going on at the time. I just wanted to clarify that because that's what I meant. I think we've got to find a way, especially as complicated and complex as these issues are today. I know that some of the states are like dealing with smart grid issues. Ohio, I'm sure you're familiar with what they did. The commission went through about a 9-month to a year process to fully educate themselves, but to flesh out all the issues with the stakeholders as well. I don't think under our laws that's permissible, but that would certainly, I was very intrigued with that. I thought that was an excellent way to educate and to make good policy.
Let's conclude with Hamilton's question, and rather than trying to ask it myself, I'd rather have Hamilton ask it in person.
Yeah, thanks, Charlie. Can you guys hear me?
Look at that beard.
I know. I'm facing Sam Watson. He's making me feel comfortable here on camera. Yeah, thanks for giving me an opportunity to ask this. Yeah, I'll just follow up on what Steve has just said and kind of what I've heard from Commissioner Fleming too, in that there's a real challenge here with the complexity and the difficulty of the issues that are before the commission, and only being able to engage those in a substantive way in litigated proceedings is very cumbersome, very difficult. I think the allowable ex parte briefing format is a good one, but I don't think it is a substitute for commissioners being able to participate in these discussions outside of that formal setting. And I don't know the North Carolina Commission rules in history as well as South Carolina, but I do see North Carolina commissioners showing up at conferences. I saw one of their commissioners, Commissioner Mitchell, participated in the E4 panel just a couple of weeks ago that I was watching. And I've never seen a South Carolina commissioner anywhere except a NARUC conference. They're completely invisible in South Carolina. And so we have this entire discussion and collaborative, whether it's collaborative or whether it's, whatever the stage is, there's a lot of activity in South Carolina around energy and increasingly so over the last decade. And the commission's been completely absent from that. And so I'm interested, especially in Commissioner Fleming's perspective, on what it was like coming off the commission and having and now being involved in conferences like this, and just having that perspective of no longer being a commission and seeing what the landscape looks like from this new perspective.
Well, first of all, I was shocked that people didn't realize what a silo we actually lived in on the commission. It actually is for real that we are totally isolated in regard to conversations, and the knowledge that we had was what was brought before the commission in the hearing room, which left us, I think, I would have, on the outside looking in, I would have, I feel like I could have been much better informed and made better decisions if there had been more of that flow of information along the way. I just feel like I said earlier, it's just so important to have those educational opportunities to find out what's going on and to be involved in the policymaking process to make good policy as a commissioner in a give and take way. I'm just my comments today, though, are trying to work within the framework that's established for the time being to move forward in making having those opportunities more available. I do think the people who are making the decisions about what is allowable and what is not, I kind of feel like it's become a lot more restrictive from where it was when I started out on the commission in 2004 as to where it was when I left the commission in 2018. I think there's an opportunity for a lot more to be done in-house, even with the restrictions we're under as a commission, than what is actually being allowed. I don't know whether it's an abundance of caution with as you move along, or if it's some of the things that happened around VC summer, or exactly what's going on. But I do think we've become much more restrictive than what the ex parte really could allow.